Welcome everybody again. This is the first hearing of the round of 16. Today we have Université Sorbonne Paris Nord acting as counsel for the appellant, and the New Vision University from Georgia acting as counsel for the respondent. The panel is composed by Mr. Azzali, Ms. Bao, and Ms. Quinn. Everybody is connected perfectly, therefore all is good on my side. I leave the floor now to the panel.
Thank you very much, Julia, and welcome to the elimination rounds. Congratulations on making it this far. We will go into character in just a second, but I just wanted to confirm that everything is in good order on your side and you can hear all of us.
Yes, there are no issues.
Excellent. Well, then let's begin. Good morning, good afternoon to you all. My name is Qian Bao. I will be serving as the presiding arbitrator today in these proceedings. To my bottom is Ms. Brianna Quinn, who is a co-arbitrator with me, and to my corner is Mr. Stefano Azzali, who is the other co-arbitrator in this matter. Before we begin, I wish to deal with a few housekeeping matters. First of all, I have personally received the skeleton arguments as well as the legal authorities that have been sent by the parties. May I confirm that my co-arbitrators have also received these documents? Thank you, and thank you for sending them over. The other matter, as you will well be aware, is that when you will understand that the videos will be turned on when you're speaking, and please do mute when you're not speaking. Another matter is in relation to timing. You will know that we have 20 minutes for each side. We plan on being strict with this 20 minutes. I, as presiding arbitrator, will keep track of the timing, but we invite you as a team to also be mindful of the time. We will be strict with timing, as I mentioned, and we will cut off as appropriate if you are running beyond the 20 minutes allotted to you. Of course, there will be opportunity for 1 minute rebuttal and surrebuttal, and so we will provide that opportunity. But otherwise, please be mindful of the timing. Now, my final housekeeping is to invite the parties to let us know whether there has been agreement on the order and how these issues are to be dealt with today. And I invite the parties to brief the tribunal on this.
Good day, Madam Presiding Arbitrator, esteemed colleagues. We have reached an agreement on the order of our submissions and the allocation of time. Appellant will start both on the procedure and merits and will be followed by respondent. All counsel will be speaking for 10 minutes, reserving 30 seconds for rebuttal and surrebuttal.
Okay.
And I would like to add one point. We would be happy to reserve 10 minutes as in line with the same rules to answer the questions of the arbitrators if just in case it's necessary and we cannot finish them within the 10 minutes.
Thank you very much. Now, to the extent that the tribunal does have questions during your proceedings, we will ensure that you have the full 20 minutes for your presentation. And so don't worry about losing time if we become a hot bench. So thank you for for letting us know as to the order. Unless my co-arbitrators have any other final comments before we begin. Ms. Quinn, Mr. Azzali? Nope. Okay, well then, may I leave it to then the appellant, please? Anytime you're ready.
It seems that the appellant's screen might be frozen.
Hello?
I don't know whether the appellant's co-counsel could maybe send her a message. Here we go.
I'm sorry. I think I had a connection problem I'm trying to resolve, but if the tribunal hears me without issue right now.
Yes, we can hear you. I can hear you.
Okay, I'm sorry. And I would be happy if you just remind me in case the problem consists, so not to miss any points in my submissions. Honorable members of the tribunal, esteemed colleagues, good morning. My name is Sıla Nazlı Kelce. Together with my co-counsel, Pierre Nelson Mwamba, we represent appellant Mr. Atom in today's proceedings. We appear before this tribunal today to discuss a 15-year-long ban imposed upon our client, Mr. Atom, who has dedicated his life to football and who has maintained a flawless track record so far. Unfortunately, FIFA reached a decision which intolerably contradicts with the sentiment of justice. That's why we will ask this tribunal to remedy this defect before, that has been done before. And before my co-counsel reveals the reasons behind that, I would like to address 3 procedural issues with this tribunal today. First, I will demonstrate why CAS has jurisdiction to hear the dispute. And second, I will invite 2 members of this tribunal today, Mr. Wax and Ms. Umayma, to resign as there are legitimate doubts regarding their impartiality. And third, I will lastly touch upon the evidence issues, namely the telegram messages and the witness statements being inadmissible. Moving on to my first submission, I would like to remind this tribunal that the CAS jurisdiction directly arises from Article 57 of the FIFA statutes, which recognizes CAS as the competent body to resolve disputes in between FIFA and its officials. And also Article 58 of the FIFA statutes indicates that appeals passed by FIFA's legal bodies can be lodged with CAS within 21 days. And also, as can be seen in the Exhibit 6, last paragraph, FIFA itself directs the appellant to lodge a claim before CAS against this decision. And as Mr. Atom received the notification of the FIFA Appeal Committee's decision on 31st of March, he filed its appeal timely on 20th of April. That's why this tribunal has the jurisdiction to hear the dispute and should do so. If the tribunal has no questions regarding this issue, I will move on to the next issue regarding the challenges against Mr. Wax and Ms. Umayma. And while doing this, I will be detailing the reasons and I will be basing my claim, my challenges on 2 articles of the CAS Code. First of all, Article 33, which requires arbitrators to be and to remain impartial during the arbitral proceedings. And second, Article 34, which enables a party to challenge an arbitrator if there are legitimate doubts as to his or her impartiality. Before detailing the reasons, I would like to remind this tribunal that we have already filed a petition detailing the reasons for our challenges with the CAS Court office in line with the CAS Code. However, it is crucial that we are reiterating our concerns today once again. And with regard to the challenge against Mr. Wax, I would like to begin by indicating that our challenge is in line with the time limits. As the appellant discovered the grounds for challenge only 3 days before today's hearing, which was a result of a total coincidence. And as the tribunal can see on the Exhibit 7 of this record, this LinkedIn comment was not even published on Mr. Wax's own profile, and its identification was not easily possible. And as was reflected in the Sun Yang case decided by the Swiss Federal Tribunal, where the arbitrator posted tweets on Twitter, detailing and manifesting his bias against the appellant. The Swiss Federal Tribunal decided that just because a certain information is accessible does not mean that it's easily identifiable, which is exactly the case here. That's why appellant's challenge is timely. And moving on to the Exhibit 7 once again, I would like to draw Tribunal's attention to the context of the comments made by him on the LinkedIn profile. And actually in this comment, he details his negative comments against the vaccine opponents by calling them free riders, egotistics, and ignorant. And as the fact pattern reveals, Mr. Atom has been the face of international criticism because of his anti-vax stance. And it is clear that Mr. Vax has a very sharp, strong criticism against those who oppose vaccine mandates, where Mr. Atom belongs to. That's why he can't judge the merits of the case impartially, as he is already filled with resentment against Mr. Atom and everything he represents. In this regard, I would like to remind this tribunal once again that we are using the definition provided by the Swiss Federal Tribunal in the Sun Yang case to define the legitimate doubts. And according to this decision, the doubts are legitimate if a reasonable third party having knowledge of the circumstances would consider that arbitrator would be influenced other than by factors other than the merits of the dispute. And it is clear in this case that Mr. Vax, also read in line with his commitment in the NGO, cannot be impartial towards Mr. Atom. That's why he should decline to sit in the panel.
Sorry, Council Chair, can I pose a question to the Council? Council, I believe that there are around the world many no-vax people. I don't know how many millions, but around the world there are many. Your argument leads to consider Mr. Vax biased with all those millions of anti-vax people. That's what you are assuming, although there would be no connection with any of them. You believe that really a position against the anti-vax people would affect his impartiality as for a case that has no relation with the vaccine, with COVID, on other issues? That's what you are assuming?
Absolutely, Mr. Azzeli. Indeed, there may be millions of anti-vaccine supporters in this world. However, when we look at them, look at their numbers statistically, they still remain as the minority in a society. And even before going to this point, actually, it is clear from Mr. Vax's statement that he is already filled with resentment. He is the president of an NGO fighting to eradicate the diseases. And he is also not taking back to publish his opinions publicly against those who oppose anti-vaccine, who oppose the vaccine mandates. That's why it is our submission that Mr. Vax cannot judge the merits of the disputes without taking into account, without being influenced actually by his stance to eradicate the diseases, which includes the COVID as well. And also there may be millions of people who are opposing vaccine mandates, but there are also plentiful of arbitrators sitting in the CAS lists. That's why the parties can make more effort to nominate another arbitrator other than Mr. Vax, who can be more impartial in this dispute. If this satisfies your question, I will move on to my second submission with Ms. Umayma. And with regard to Ms. Umayma, I would like to indicate that Ms. Umayma failed to disclose his previous appointments with the proceedings where FIFA was a party. and therefore she breached the IBA guidelines orange list. And the procedural order reveals that these decisions were not publicly available. That's why appellant had to ask them from Ms. Umayma to examine the grounds of the decisions, the context, and whether these decisions contained a pecuniary sanction or not. However, it was not incumbent upon appellant to ask it, but it was incumbent upon Ms. Umayma to reveal them before today's proceedings. And moreover, the multiple nomination in this forced arbitration should not be considered as justified grounds, as it has been already criticized by practitioners. That's why the parties should be more cooperative and more proactive while they are selecting their arbitrators. And also, as the fact pattern reveals, she recruited a former FIFA counsel who worked there more than 5 years, which means that who has profound connections with FIFA, and that's why who can serve as the communication means in between Ms. Umayma and FIFA. That's why Ms. Umayma cannot remain impartial and independent in this case, and she should also decline from sitting. If the tribunal has no further questions, I'm moving on to my next submission regarding the admissibility of the evidence, and I will begin with the telegram messages. First, I would like to indicate that these messages are not admissible as their authenticity is disputed. And second, FIFA hasn't proved having clean hands as to the procurement of this illegal evidence. And I would like to indicate a decision given in an ICSID arbitration where the tribunal decided to exclude an audio tape because it was manipulated and its authenticity was not confirmed. Therefore, this tribunal should follow the same manner and should decide to exclude this evidence. And moreover, the authenticity is also incumbent upon the FIFA to prove, as this civil code requires each party to prove the existence of the facts that they rely upon. And the last point is that its source is unidentified, and as per the good faith principle, FIFA should prove that it is not him who hacked the evidence or who provoked a third party to hack it. Unless these substances are proven, this tribunal should decide to exclude this evidence. And
sorry, counsel. Sorry, counsel. May I? You mentioned at the beginning that this evidence is illegal. Would you please explain a little bit more? Because I did understand your argument as for admissibility of the evidence, but as for its lack of legality, I would like you to explain a little bit more to the arbitral tribunal this concept.
Yes.
Thank you.
Indeed. Mr. Azeli, it is our submission, just to clarify, that first, this is not admissible because its authenticity has not been confirmed. And second, because FIFA has not proven having clean hands to procure this evidence, which has been obtained by illegal means. And actually, it is obvious from the fact pattern that this message was hacked and whose resource is unidentified. The fact pattern reveals that we do not know the person who hacked this message. It also reveals that the date of this message is unknown. So this leaves us a very vague evidence to rely upon FIFA's arguments. And that's why actually we are using the illegality to say that it's FIFA who should prove that it did not breach the good faith principle to procure this evidence. And I'm moving on to the last part of my submission, which concerns the witness statement. I would like to indicate that we do not contest the fact that anonymous witness statements can be admissible in Switzerland, also in civil proceedings in Switzerland. However, their admission is subject to strict conditions. Swiss Federal Tribunal listed 3 conditions for an anonymous witness statement to be admissible, which are as follows. First, there has to be a concrete risk of retaliation. Second, this anonymous witness must be seen by the court and must be questioned by the court. And third, this person has to be cross-examined through audiovisual system. And in this case, this tribunal can see from the procedural order that this witness, this whistleblower, was not questioned at all by FIFA. And the appellant was not given a chance to cross-examine, which fundamentally breaches the conditions of admission of an anonymous statement. And as the last point, we would like to remind this tribunal that Heartland was not a party to the European Court of European Convention on Human Rights. That's why appellant cannot even make sure as to the method about the procurement of this witness statement. And moreover, alternatively, we are asking this tribunal to hear this anonymous witness once again, in line with its power to hear the dispute de nouveau. And if the tribunal has no further questions, I would like to conclude my arguments by saying that first, the CAS is the competent body to hear the dispute. And second, challenges against Mr. Wax and Ms. Umayma should be upheld and they should resign from sitting in the tribunal. And third, the evidences, namely telegram messages and witness statements, are not admissible. Thank you.
Thank you very much.
May I proceed, Madam Presiding Arbitrator?
Yes,
thank you, Madam Presiding Arbitrator. Honorable members of this tribunal, esteemed colleagues, as earlier stated, my name is Pierre Nelson Muamba, and I will make 2 submissions as regards to the merits of the present case. The first is that the appellant did not breach Article 27 of the FIFA Code of Ethics, and the second is that the sanction imposed on the appellant was disproportionate. Regarding the first submission, I will explain why the evidence provided by respondent, namely exhibits 4 and 5, lack probative value, before I demonstrate that respondent failed to establish the existence of a quid pro quo as required by Article 27 of the FCE. Regarding the first argument, as earlier argued by my co-counsel, the appellant primarily seeks for this tribunal to reject exhibit 4 and 5 as inadmissible. But were this tribunal to decide otherwise, it will still have to assess, to evaluate the evidentiary value of these pieces of evidence. And to do so, it will have to do it to its comfortable satisfaction in accordance with Article 48 of the FIFA Code of Ethics. And when assessing the probative value of exhibit 5, the screenshot of the alleged conversation between Mr. Lenders and the appellant, displayed on page 13 of the electronic record, this tribunal may take into account that respondent has provided no clarity as regards to the authenticity of that piece of evidence. It may also take into account that the screenshot is undated and therefore cannot be used to ascertain a precise timeline of the event. And additionally, the panel may take into account that it has been easily manipulated by simply using a photo editing software. And in its assessment of the probative value of exhibit 4, the witness statement, which is displayed on pages 9 to 12 of the electronic record, the panel may take into account that the witness made his statement on December the 5th of 2017, and that the conversation between the appellant, Mr. Kaiser, and Mr. Lenders took place on July the 28th of 2016. So more than a year have passed between the date of the witness statement and the date of the conversation between the appellant, Mr. Kaiser, and Mr. Lenders. And the passage of such an amount of time significantly undermines the reliability of the recollection, of the witness's recollection of the exact content of that conversation or of any event that might have occurred on this occasion. I would like to conclude on this argument by reminding the panel that comfortable satisfaction is a high standard of proof. As explained by Professor Antonio Rigozzi and Brianna Quinn in an article mentioned as AL15 provided by the appellant, comfortable satisfaction is a standard stated to be lower than the criminal standard of beyond reasonable doubt, but higher than the civil standard of the balance of probabilities. If the panel doesn't have any question in that regard, I may now turn to my second argument.
Yes, please.
Thank you, Madam.
Council, just so you know, we have currently allotted less than 3 minutes for the remaining session. So please use your time accordingly.
I didn't hear you, Madam Arbitrator.
Pardon, I just said that just to remind you that we have less than 3 minutes left remaining in your 20-minute session. So please use your time accordingly. Thank you.
May I ask you for an additional minute?
Co-arbitrators, are we okay with that? Yes, that's fine. Thank you.
Thank you. So I will quickly address the second argument relating to the first issue, that respondent did not prove the existence of a quid pro quo as required by Article 27 of the FCE. So for a violation of Article 27 of the FCE to occur, respondent must prove that there is a connection, a ratio of equivalence between the advantage allegedly received by a FIFA official and an action by the FIFA official allegedly obtaining the said advantage. And respondents may argue that Mr. Atom's trip to Bigland was itself an undue advantage, in exchange of which he decided to vote for Bigland. But as it is clearly stated on the first procedural order, page 5, paragraph 3, Mr. Atom and Mr. Lenders were guided during their trip to Bigland, they were guided to visit to Bigland's touristic points, stadiums, and training facilities. So these are these visits that motivated Mr. Atom to choose Bigland. And according to the Teixeira case, AL number 12, provided by the appellant, four cumulative requisites are needed, must be proven to establish the existence of a quid pro quo. As earlier stated, the appellant went to Bigland to assess the quality of Bigland's candidacy for the 2026 World Cup application, and this is a legitimate motive for a trip to Bigland. And one of the four requisites to establish a quid pro quo is the existence of an illegitimate motive. So that requisite being missing, respondent hasn't proven the existence of a quid pro quo, and respondent having failed to establish that a quid pro quo existed, it has failed to prove that the appellant reached Article 27 of the FCE. And if the yes, Mr. Arbitrator.
Yes, sorry, counsel. One question. I know that you are running out of time, and I blame on me. But one question: is it correct that Mr. Atom's wife would have received an advantage in case the match between the two teams, as agreed by the parties, were taking place in Mr. Atom's, let's say, under Mr. Atom's federation auspices? Am I right that she might have received an advantage, being very active in a broadcasting industry? Am I right?
To answer your question, Mr. Arbitrator, I would like to first remind the panel that this alleged advantage was, it's the witness who mentioned this alleged advantage. And as earlier stated in my first argument, the probative value of the witness statement is highly questionable. And as regards to Mr. Aitem's situation, it is stated in the procedural order that her broadcasting company is not related to football and that she only owns a little sharehold in this company. So she wouldn't have necessarily benefited from the alleged agreement between FFV and FFT. If this satisfies you, Mr. Arbitrator, I will now address.
Yes, absolutely. Thank you.
Thank you, Mr. Arbitrator. I will now quickly move on to addressing the second submission, which is that the sanction imposed on the appellant was disproportionate. As stated by Paolo Garafa, AL 13, provided by the appellant, amongst the sports law principle, there is the principle of proportionality of the sanction. In that case, the sanction imposed on Mr. Aitem is disproportionate, all the more comparing with previous sanctions imposed on FIFA officials involved in previous bribery cases. And in that regard, I may turn the panel's attention to AL 11, the bribery case involving Mr. Osiris Guzman, who was the president of the Dominican Football Federation and who had already been suspended, banned by the ethics committee for a period of 30 days. And in this decision, the panel decided to reduce Mr. Guzman ban from 10 to 7 years after he had already been banned first time. In the present case, Mr. Aitem has never committed prior breaches of the FCE or of the FIFA statutes and regulations in general. And the respondent also failed to take into consideration mitigating factors, such as the fact that Mr. Aitem, as I just said, hadn't committed prior offenses to FIFA statutes and regulations, and that he actually returned the 20,000 Swiss francs, which covered his and Mr. Lander's expenses for their trip to Bigland. And another point that I would like to quickly address is that respondent provided no clarity as to how the fine was calculated. As stated in AL 9, the case involving Kwesi Nyantaki, the minimum basis for the calculation of the fine is the amount deemed to have been received as a bribe, which can be added a certain amount to ensure a deterrent effect. But in the present case, given that Mr. Aitem has returned the advantage he had allegedly received from Mr. Kaiser, the 20,000 Swiss francs, which by the way is the only figure available, it should have been credited to Mr. Aitem, and the respondent should have taken that into account and accordingly reduce the sanction imposed on Mr. Aitem. And I will now summarize my argument, my submissions, by saying that the appellant submits that he didn't breach Article 27 of the FIFA Code of Ethics. However, were this tribunal to decide otherwise, the appellant submits that the sanction imposed on him was disproportionate and that they should be reduced to a warning or a reprimand, or at the maximum to the minimum of 5 years provided for in Article 27 of the FCE. Thank you, members of the panel.
Thank you very much.
Sorry, if I may, I do have one question.
Yes.
If you could just remind me again of the precise cases that you cited in terms of the sanction that should be applied on the appellants, the comparative cases.
I mentioned the bribery case involving Osiris Guzman, AL 11. Mm-hmm. And for the fine, I mentioned the case involving Kwesi Nyantaki, AL 9.
Okay, thank you.
Thank you very much. Unless we have any other questions from the panel, I think we can then turn it to the respondent, please.
Honorable Tribunal, my name is Alexander Kharatishvili, and together with my co-counsel, Ms. Tatiana Nikashvili, I represent respondent in today's proceedings. I will address the procedural issues, while my co-counsel will argue on the merits of the dispute. Members of the tribunal, this case is about appellant selling his vote in World Cup elections and now trying to avoid liability for his own unethical actions. This is why appellant raises unfounded challenges with respect to the constitution of the tribunal and with respect to the evidence. Mirroring my opposing counsel structure, we will demonstrate that first, the challenge of Mr. Andre Wax and Ms. Sara Umayma should be rejected, and second, the evidence submitted by respondent shall be admitted in the case. However, as a preliminary matter, let's briefly discuss our position on the admissibility of the appeal. Mr. Atom made a mistake when he applied to FIFA Appeals Committee. He should have directly applied to the CAS. Thus, formally, he has missed 21 days, that is the deadline for approaching the CAS. Nevertheless, since FIFA Appeal Committee also contributed to this mistake to some extent, we do not want to deprive appellant of the possibility to take his case to the CAS. We therefore confirm that the appeal is admissible. Now, as regards the challenges, it was also noted by my opposing counsel that this panel does not have an authority to decide on the challenges, and the final decision will be made by ICAS. Starting with the challenge of Mr. Andre Wax. The first reason why this challenge should be dismissed is that it has been brought outside 7-day time limit as prescribed by Rule 34 of the CAS Code. The comment was made on 20 November 2021. The challenge has been raised at the present hearing, that is more than 3 months after the comment was published. Now, appellant has argued that the late finding of the comment is excusable. We must disagree. It is well accepted that duty of curiosity also includes investigation on the internet. Members of the tribunal, LinkedIn has the highest domain authority. That means if appellant had just Googled the name of Mr. Wax, his LinkedIn profile would have been on the first page of the list of search results. Accordingly, appellant was reasonably required to have found Mr. Wax's LinkedIn profile, which would have inevitably led to the finding of the comment. First, the comment was publicly accessible. Second, the comment was made only 9 days before the appointment and it was still fresh. Third, and most importantly, this is the only comment which Mr. Wax has made on LinkedIn ever. Thus, we do not face the problems of identifying the ground for the challenge, and we cannot rely on the Sunyan case which my opposing counsel has invoked. Appellant also noted that this comment was made on another person's account, and this logic is correct when we are talking about Facebook or Twitter, but LinkedIn is different, as LinkedIn shows every comment which a particular account makes even on another's posts. Therefore, we had only one comment and it would have been easily available for appellant to find the comment. Therefore, the challenge is late and must be dismissed. Even if the tribunal considers that appellant has met his duty of curiosity, the challenge should not be upheld on the substance. The Swiss courts are very restrictive when it comes to legitimate doubts over arbitrators' impartiality. Appellant relies on the wording of the comment to make an impression of bias. However, the tribunal should take into consideration that first, as it was also reasonably identified by this tribunal, the comment is not even directed to appellant. Second, Mr. Atom has already been criticized worldwide for his anti-vaccination approach. This means Mr. Wax's comment on vaccination should not be singled out as an attack on Mr. Atom, and it is not therefore the ground. Third, the comment was made following Mr. Wax's role as a president of his organization and is in no way related to the present proceedings. In fact, Mr. Wax may not even have known about appellant's take on vaccination had he not brought the challenge. Although it is apparent now, as long as Mr. Wax is confident, we are also confident that this won't affect his ability to adjudicate with free mind. Now, as regards the challenge of Ms. Umayma, the maximum number of cases she could have been specifically appointed by FIFA is 2. This is the minimum number for appointments to be considered as repeat. It would have been mathematically impossible for FIFA to avoid all this because of the closed list of arbitrators and required specialized knowledge. To clarify, In 2021, FIFA has appeared before CAS in 142 cases, while there are only 125 arbitrators on the football list. And this is precisely why IBA guidelines on the conflict of interest establish that no disclosure is needed for repeat appointment in sports arbitration. Also, appellant relies on the IBA guidelines. It fails to note that footnote 5 to Article 3.1.3 states that there's no need to disclose repeat appointments. All the more, it has been decided by ICAS in Contador case that 4 repeat appointments were not sufficient for the challenge. As regards FIFA's former member joining Ms. Omaima's law firm, the past links of employment are not ground for the challenge, and this has been held by the Swiss Federal Tribunal in its decision in 2001. In light of all the above, the challenge of Mr. Andre Wax and Ms. Sarah Omaima should be rejected.
Sorry, Ms. Manin, if I might, I just have one question about your point on the comments on LinkedIn. I'm not sure I understood how it's different from Facebook, for example, how it's easy to see a comment that someone on LinkedIn has made on someone else's account. Do you need to do any research on that, or is it completely obvious from the get-go?
Mr. Arbitrator, Madam Arbitrator, my apologies. I will specify that LinkedIn has a special section, and when you go to account of a particular person, it is obviously seen. Without any further research, you can see the comments and activity which a particular person did on LinkedIn. Therefore, there is no further need to make additional research, as it is clearly seen on the front page of the account.
Okay, thank you.
Thank you. Now, in the interest of time, I shall now proceed to admissibility of evidence. We have admitted 2 pieces of evidence. Let's assess their admissibility separately, bearing in mind that bribery is concealed by nature, which makes it practically impossible to obtain any direct evidence. Starting with illegally obtained Telegram conversation. Such evidence is admissible under Article 152 of the Swiss Civil Procedural Code when there is an overriding interest in finding the truth. It has been held in Adamu and Fusimalohi cases that fighting the corruption is an overriding interest. FIFA has the policy of zero tolerance to corruption, and all the more in World Cup elections. We also emphasize that this evidence was provided by a third party without respondents' any involvement. Appellant failed to meet the burden of proof under Article 8 of the Swiss Civil Code to demonstrate that this evidence has been forged. Also, my opposing counsel relied on the ICSID case. The factual background of those cases are very different. In ICSID case, it was claimant who had the knowledge and possession of the comments of the conversation, and therefore claimant also invited various experts to examine the authenticity of these conversations. And following the conclusion of the experts, authenticity could not have been identified. Therefore, this was main reason why that evidence was not admitted. But in the case, appellant failed to demonstrate that this evidence has been forged or its authenticity cannot be identified. Now, in the interest of time, I shall now move to my last submission, that is anonymous witness statement. And the use of anonymous witness statement is allowed under the European Convention on Human Rights, even in criminal proceedings. The anonymity is necessary in this case as the personal safety and health of the witness is at stake. The main question is regarding its credibility. For instance, in Contador case, the court did not admit the evidence as it was necessary to make sure that the person giving the statement really existed. Now, seeing my time has almost expired, I respectfully request time extension for 30 seconds.
I interrupted you before, so.
Thank you very much. Now, we do not face this problem in this case. The witness statement has already been admitted and used by a judge in criminal proceedings in Hardland. This could not have been done without proper credibility check into the identity and reputation of the witness. Also, appellant realized that Hardland is not a party to the European Convention on Human Rights. That does not mean that evidence should not be admitted. For instance, in Teixeira case, the court relied on the evidence which was admitted in the United States, which is also not the party to European Convention on Human Rights. Therefore, this evidence needs to be admitted. As regards the inability to cross-examine the witness, that does not prevent this tribunal to admit this evidence as a documentary evidence in line with past practice established in noted Teixeira case, also NNV case. And appellant will be given an ample opportunity to comment on this evidence within these proceedings. With that, I would like to conclude that the challenges should be rejected and the evidence admitted in the case. Thank you.
Thank you very much. Ms. Nakvashali.
Good day, members of the tribunal. Representing FIFA in this case, I will address the substantive issues, establishing that first, appellant committed bribery, that is the most serious violation prohibited under Article 27, and second, the sanctions imposed are clearly proportional for this violation. As a preliminary matter, I would like to direct the panel's attention back to the submissions made by my co-counsel that all of the evidences shall be admitted in this case, and coming from that basis and in response to what appellant has said, respondent will demonstrate to the comfortable satisfaction of this panel that appellant has accepted undue advantages from Mr. Kaiser in exchange for him obtaining a favorable vote in the World Cup elections. Even if the evidence is not admitted, the facts are clear and supports this charge, and they are strong and reliable. And by taking all together the facts and evidences, the panel can see the whole picture to the comfortable satisfaction. To start with, it is uncontested that appellant has enjoyed a 7-day all-inclusive luxurious trip to Bigland, which started with business class tickets and ended with the Michelin star restaurant, all at the expense of Mr. Kaiser. It is also undisputed that Mr. Kaiser openly asked appellant to vote in favor for Bigland in the upcoming elections. It is also undisputed that appellant and Mr. Kaiser agreed on having a friendly match and without requiring any payment. Without this, the agreement would be at least 50-50. Now, the fact that the match never took place is of no relevance because it is established in various CAS cases that the advantage, it is not necessary for the advantage to be actually received, and only the acceptance is already sufficient. I would like to direct the panel's attention to the page 2 of the case file. Paragraph 1. Is the tribunal with me? Here, the last line clearly states that the wife of appellant is a shareholder of the only football broadcasting company in Thailand. And contrary to my opponent's submission, it is true that the football broadcasting company is this one in which the appellant's wife is a shareholder. Also further, we know that representatives of 5 other federations who were invited to similar trips and voted for Bigland were charged with bribery by the courts in Heartland, and so was Mr. Kaiser. It was on the 2nd day of the Heartlandian criminal proceedings when appellant, only after 2 years, restituted 20,000 to Mr. Kaiser. If anything, this shows that Mr. Atom was trying to escape the liability and he know that he conducted the offense. All I have said so far is based on undisputed facts, which paint a clear picture of committed bribery. In all 3 instances, there was an acceptance from an official, Mr. Atom, of undue advantages, namely the waiver of the friendly match revenue and the luxurious trip. And in addition, there is evidence suggesting that appellant also accepted a luxurious watch. We also emphasize that under Article 27 of FCE, any benefit is satisfactory, any amount of benefit is satisfactory to deem the violation, as stated, for example, in Gaza or Teixeira cases. Appellant here now demonstrates—
Sorry, counsel.
Yes, Mr. Arbitrator.
Sorry to interrupt you. You're saying that for a bribery, there is no need to be a proportion between the advantage gained by one party and the advantage gained by the other party. In other terms, I believe that organizing a World Cup has a very high economic value for a federation / for a country, very high. It's a big event. On the other hand, so the advantage for the hosting organization is high. On the other side, the advantage for the voter, let's say for Mr. Atom, was 1 week in a hotel, few dinner, maybe a watch. Don't you think that there is really no proportion? I mean, I think that one vote might value more than 1 week of. So it was a good price for to collect one vote for the hosting organization. The bribery was quite cheap. Don't you think
indeed,
that,
Mr. Arbitrator, the proportionality may be taken during imposing the sanction as under Article 27(3). However, I would like to emphasize that Article 27(1) of the FCE clearly states that any improper advantage is enough to deem the violation. Therefore, even the small amount of bribery is already sufficient. And also we submit that this friendly match would have been very important for Thailand as well, because the Big Land is one of the most famous and biggest football federations, and therefore it would be important for both of the federations to have a friendly match, and this shall also be taken into consideration by the panel. And to resume my submission and to submit regarding the ratio of equivalence, it is the position of respondent that there is indeed the quid pro quo, and panel shall be comfortably satisfied that there is a ratio of equivalence because appellant sold his vote when he sua sponte voted for Big Land, and appellant tries to mislead the panel regarding the nature of the trip. There is nowhere in the case file stated that appellant visited Big Land to assess the quality of the stadiums and other factors regarding the host selection in the World Cup. But the concealed nature of this trip was indeed to discuss business opportunities and to cast a vote in favor for Big Land in exchange for this advantages and rewards. Also, the timing is not a coincidence. The trip took place only just several months before the elections, and there is no legitimate basis for any of the advantages accepted. Therefore, the ratio of equivalence is apparent, and also the Exhibit 5 on page 13 of the record clearly shows that appellant indeed felt he owed Mr. Kaiser a vote. I quote, "After all they did for us, the least we can do is to vote for them," end of quote. Therefore, it is apparent that there is the ratio of equivalence, and to conclude, the panel shall be comfortably satisfied if not beyond the reasonable doubt that there is a breach of Article 27(1) of FCE. And now to move to the second submission regarding the sanction, we submit that the fine of 50,000 and the ban of 15 years is clearly proportional and adequate to this offense, and tribunal shall neither cancel nor lower the sanction. Proportionality should be assessed under the relevant rules, that is the FCE, and in comparison with FIFA's decisions. And as stated by my opponent in Guzman case, it is emphasized that the CAS has restricted powers, and it reviews sanctions only in the extreme cases. The arguments made in Guzman case is not relevant here in this case, because in Guzman case, the CAS found that only 2 offenses were committed instead of the original 3, and that was the reason why CAS lowered the sanction imposed. Here, we know that appellant committed the bribery and there is no other offense to be discussed. The legal interest protected under Article 27 refers to the trust in the integrity of the individuals in FIFA's powers. And according to FIFA Disciplinary and Ethics Committee 2020, FIFA now firmly stands to its position of zero tolerance against corruption that causes grave external effects, including to the trust in FIFA. And consequently, FIFA has the direct and pressing interest to impose effective sanctions, and that is enshrined also in FIFA statutes under its Article 2. I would like to request the panel extension for 1 minute to substantiate my arguments.
It's a very brief 1 minute, thank you.
Thank you. Also, appellant submits that the bribery is the most serious offense, and it is also stated in Guzman case. And for bribery, there are life bans imposed, for example, in Teixeira case or in Collier case. And CAS emphasized that the sanction should be sufficiently high to confirm the corruption offenses are not taken lightly. It is also worth noting that bribery is a criminal offense under Swiss criminal code that further emphasizes its serious nature. And regarding the calculation, the committee of the appeals committee took into consideration that appellant restituted 20,000, and this is the benefit that was received by appellant, and it is obvious that he himself considered this to be the benefit. Therefore, the math is clear. Thus, respondent submits that there is no ratio to further lower the sanction and review the sanction imposed by appeals committee. And thus, I conclude my submissions and request the panel to dismiss the appeal. Thank you.
Thank you very much, counsel. I know that we had allotted time for SIR rebuttal, but we have now run out of time for the entire moot. Unless the parties feel a dire need for a rebuttal or SIR rebuttal, I think we might pass on that. Please let me know your views.
Respondent side totally agrees, Madam Presiding Arbitrator.
Thank you.
We would be happy to just make one remark regarding a case law referred by the appellant.
Okay, I think you had allotted 30 seconds, so we will grant you the 30 seconds.
Okay, thank you. Just to indicate that he referred to Teixeira case. However, it's not applicable because the identities of the witnesses were known in this case, and the witnesses were active participants of the bribery scheme, but they were not bystanders. But here, the witness is anonymous and he cannot even identify the individuals as he just solved a year back. That's why it should be not even taken into account as a documentary evidence.
Thank you. That was a quick 30 seconds, so thank you for that. So this concludes our session together. I believe that we can now move into deliberations. If the SAM organizers are behind the scenes and think otherwise, please let us know. But otherwise, co-arbitrators, can you please join me in the breakout room, please?
Congratulations to everybody.
We also congratulate. This is a very good achievement we both have done, and yeah, thank you for pleading with us.
Yes, it was a pleasure to plead with you guys.
Thank you as well for us.
I agree, and it was really pleasant for me to see some of our arguments be used against us. You know,
we are on the same page.
And we're also pleading both sides. So we're also.
Yeah, there are just two of us in the team.
And We also noted some arguments in your submission.